We'll start with some broad GDPR themes here on slide 4. For background, the General Data Protection Regulation, or the GDPR, entered into force on May 25, 2016, and it replaces the existing Data Protection Directive, which was enacted in 1995. As I mentioned, the GDPR is a regulation, and the existing law is a directive. Those terms are meaningful from a European law perspective. As a regulation, the GDPR will be directly applicable in each EU member state starting on May 25, 2018, without any need for transposing the regulation into national law at the member state level. This is very much different from the existing directive, as directives set the floor under European law, but member states can implement essentially their own version of the law. This regulation should result in fewer divergences across the EU member states, but there are still opportunities for member states to diverge in certain areas under the GDPR, such as with respect to children's privacy, data protection officers, etc. So this is not a situation where the individual member states become completely irrelevant from a data protection perspective, which I think is important to keep in mind. As a substantive matter, the GDPR includes some very, very significant changes over the directive, and I've listed some of them in this slide. Going through them, first, accountability. There are a number of requirements in the GDPR aimed at creating more accountability from a data protection perspective. These include the requirement to appoint data protection officers, or DPOs, as you'll hear them referred to as, to maintain internal records of your data processing, which generally replaces the existing obligation to register your data processing with data protection authorities or supervisory authorities, and for you to conduct privacy impact assessments to evaluate risk when you're developing new products or services that involve the processing of personal data. In addition to accountability, there are also expanded data subject rights under the GDPR, which we will focus on a little bit later. The same goes for heavier sanctions. This has been a much publicized aspect of the GDPR, and we'll spend a little more time with that issue as we go through the deck. Another important theme under the GDPR is direct liability for data processors. In the past, data processors were not directly subject to data protection law in Europe, but instead the controllers were required to enter into agreements that bound the processors to comply with data protection law. Now that changes. Data processors will need to answer to the supervisory authorities directly for their compliance with applicable provisions from the GDPR. I've also listed here special provisions for children. Under the GDPR, if you are relying on consent as your legal basis for processing data, particularly of a child under the age of 16, then you will also need parental consent. Member states are free to set a lower age, provided that that age is not below 13 years old. Last but not least is coordinated supervision. This essentially relates to processing that impacts data subjects in multiple EU member states. The GDPR contemplates that the supervisory authorities in each relevant member state may coordinate with one another on enforcement, which we will discuss later in more depth. So jumping into the scope discussion, both substantive and territorial, from a substantive perspective, the existing directive, as I said, only applies to data controllers, and the GDPR scope has been expanded to include both controllers and processors. In terms of territorial scope, the directive applies to controllers that are established in the EU, which essentially means they have a physical presence in the EU, or controllers that don't have such a physical presence but use equipment in the EU to process personal data, such as through cookies on a website, for example. The regulation changes this. The territorial scope is far wider, and it applies not where equipment is used by a company, but if a company supplies goods or services to EU data subjects or monitors EU data subjects, such as through online behavioral advertising, for example. If those things happen, the law will apply to you no matter where you are established physically. In the U.S., this means, as a practical matter, that a company selling goods to Europeans online, for example, that does not have a physical presence in Europe, will now be subject to the GDPR, which is a significant change. Accountability requirements. I mentioned these accountability requirements in my introductory remarks. This is a series of requirements under the GDPR that, when taken together, are intended to impose requirements on organizations to be accountable to data subjects with respect to the processing of their personal data. I've listed a few of these requirements on the slide here. I'm starting with internal records. This replaces the requirement to register with the data protection authorities. Companies, both controllers and processors, are now required to maintain a record of the data that they hold, why they use it, to whom they disclose it, etc. This has always obviously been a best practice because it's difficult to build any sort of compliance program around data protection when you don't know the data that you process. But now it's a legal requirement to do so, which ups the ante. I've also listed here Data Protection Officer. This concept was brought into the GDPR from existing German law, where a DPO has been required for many years. Under the GDPR, companies, both controllers and processors, are required to appoint a DPO if the company's core activities involve regularly and systematically monitoring data subjects on a large scale, or if the organization's core activities involve the large-scale processing of sensitive data, such as health information. We know from the guidance that's been issued by the Article 29 Working Party that the core activities generally do not include human resources activities. So this has to be something more than human resources activities in order to be required to appoint a DPO. If you do need to appoint a DPO, the role must be independent, it must report to the highest levels of management, and it must address compliance issues under the regulation. And this individual would be responsible also for managing relations with the supervisory authority. Another accountability requirement are the codes of conduct and certifications. Possession of a formal certificate or public adherence to a code of conduct can demonstrate that a controller or processor is meeting the requirements of the regulation. Codes of conduct have existed under the directive, but the concept of formal certification under the GDPR is new. It's not entirely clear exactly how these codes of conduct will play out under the GDPR, but it is important to note that within the EU, adherence to an approved code is merely a sign to data subjects and others that the controller or processor seeks to comply with the regulation. It does not provide any form of safe harbor from action by a supervisory authority, but for companies that do certify in this way, it could be relevant when the level of fine that the regulator is considering in connection with an alleged violation of the regulation is being thought about, and it also could count as part of the measures adopted by the organization to deliver accountability. I've also listed data protection impact assessments here. In certain processing contexts involving heightened risk to data subjects, companies are required by the GDPR to carry out an impact assessment before the product or service is rolled out. As a practical matter, the fundamental aim of the assessment is to weigh the need for and the potential benefit of the processing against the impact on the individuals whose data are being processed. In the UK, the use of these types of assessments has been mandatory for various government departments for a number of years, and they are widely used by data controllers in the private sector. I've also listed here data protection by design and by default. This requirement provides that appropriate measures to implement data protection principles and to safeguard data must be put into place in an effective manner at specific points in a project. Moving on. Data security, risk assessments, and safeguards. No processing of personal data, obviously, is without risk. And this is recognized by the drafters of the GDPR. But the GDPR does require that companies address this risk by applying appropriate safeguards to reduce the risk to an acceptable level. If you look at Article 32 of the GDPR, a number of specific security measures are listed as suggestions for companies to consider when developing their safeguards. This includes safeguards such as encryption and pseudonymization, which is a European concept that involves replacing names with unique numbers and keeping the identifiable information separately. In determining the appropriate safeguards and procedures, the controller and processor should take into account the state of the art. In other words, what technology is currently available and the cost of implementation of such technical and other measures. At this point, it's not entirely clear whether the size and resources available to an organization will be a relevant consideration in determining whether costly state-of-the-art technology should be employed. So this is something to keep an eye on. Companies also must ensure that their safeguards include technical, organizational, and administrative safeguards. Technical safeguards being things like firewalls, passwords, encryption. Organizational safeguards being things like ensuring appropriate access to your facilities and to places within your facilities where personal data is stored. Administrative safeguards are the types of policies and procedures I've listed in this, or the policies and procedures I've listed in the slide that are in place to facilitate the protection of data. These security requirements in the GDPR are largely the same as those that exist under the directive. They will, however, take on a newfound importance given the breach notification requirements of the GDPR, which we will talk about shortly. Keep in mind, as we're talking about this, that although a data breach may be reportable under the GDPR, it is not, in and of itself, a violation of the GDPR. That being said, the supervisory authorities will certainly explore a company's compliance with these affirmative data security obligations, and thus it is really important that you both have the appropriate safeguards in place, but also the ability to communicate those safeguards to regulators, which requires that they have been developed in a thoughtful manner and in writing. On to breach notification. From an American perspective, this topic should really not be anything new for this audience. In the EU, however, this is an absolute game changer. A handful of EU member states previously have had notification requirements or guidance in place, but this requirement from the GDPR will be an across-the-board notification regime in the EU. Under the GDPR, controllers must notify the competent supervisory authority within 72 hours, yes, 72 hours, of becoming aware of the breach, unless the breach is unlikely to result in a risk to the rights and freedoms of natural persons. There's a couple of loaded terms of art in that expression that I just used, and I think that the real action in this standard is going to be on when a company A becomes aware of a breach, and whether B, it is unlikely to result in a risk to the rights and freedoms of natural persons. In our experience handling in the U.S. well over 1,200 data breaches over the last 12 or so years, the risk threshold here is actually quite low in the GDPR. And so most modern day breaches that we work on would likely satisfy this threshold. And when you combine that with the penalties that we'll talk about that are associated with potential non-compliance with these notification obligations, we would expect that most companies will interpret this low risk threshold bar in a very conservative manner, which at the end of the day means that we expect a lot of breach notification post-GDPR. In addition, as I mentioned, I think the become aware language becomes just critical for organizations, as it underscores the need to have airtight incident response plans in place so that breach events are quickly escalated to the right folks, because in our experience, 72 hours is an almost impossible standard for most companies. As a practical matter, it's going to mean that most companies will be in the unenviable position of having to notify a regulator when they know very little about a breach event. And to do this effectively will require substantial advanced preparation before the clock starts ticking when you become aware of an incident. In addition to regulators, controllers also must notify data subjects where there is a high risk to the individual's rights and freedoms. Again, there is some vagueness with this standard, but any data breach that involves data elements such as a national ID or financial information or health information or even some information that's not sensitive but that could result in a high risk to the individual. Think about the Ashley Madison breach where, essentially contact information was taken, but it was taken from a website that essentially facilitates illicit affairs, was compromised. In those types of situations, even where the data elements may not be sensitive, the nature of that data and who was holding it would require notice to individuals in the EU. This is obviously a sea change, and it's likely to result in the parade of horribles that all of you have witnessed in the U.S. resulting from breach events. And this includes hiring outside counsel, hiring forensic investigators, hiring public relations firms, setting up call centers, purchasing fraud monitoring products, and resolving business and regulatory disputes. This can be, as many of you probably know personally, this can be an expensive proposition. But it also has a substantial impact on related matters, such as deal negotiations when personal data is a significant aspect of the deal, and also things like cyber insurance considerations to help you manage the liability. Just to put a cherry on top here, unlike controllers, processors are only required to notify controllers when they've had a breach, and the controller bears the responsibility or the burden of notifying regulators and individuals as appropriate. We flagged data subject rights as one of the important areas of change as well under the GDPR. This slide gives you an overview. Some of these rights will be familiar if you're familiar with the existing data protection directive. Subject access, rights to object to the processing of personal data, which of course includes the right to object to direct marketing, and the right to object to automated decision-making are part of existing law. Other data subject rights are new or they've been revised. The right to port or transfer personal data from one provider, for example, a bank, to another is new. And in a sense, it's an extension of the existing subject access rights that data subjects have under current law. This right of portability is not unconditional, however, as it only applies to personal data that have been processed on the basis of consent or a contract, and where the processing is carried out by automated means. Potentially, in my view, the biggest extension of the rights is the right to erasure, referred to often in the media as the right to be forgotten, also in many of the debates and discussions that led up to the agreement on the GDPR. The right to be forgotten will give data subjects increased control over the personal data about them, with the associated challenges that will bring for data controllers. We're going to look at how this will work in a bit more detail. But at this stage, it's important to recognize that in practice, this right will not operate as a standalone remedy in most cases. It's really linked to the right to restrict personal data and the right to raise an objection to processing. So, diving in on the right to be forgotten or the right to erasure, a few important points I've listed in the slide. First, it's not an absolute right. It can only apply in certain cases, such as where the data subject has successfully exercised their right to object to the processing in question. So as I've explained, these rights are intimately linked with one another. It should be noted that a data subject cannot exercise a right to object to processing where the data controller is processing the data under a legal obligation. An objection can only be raised where the processing is carried out on limited grounds. So it follows that the data subject will not be able to have data erased, for example, where it's being processed by tax authorities. The second set of cases where it applies are where the data controller is actually processing in breach of the regulation. For example, the controller has no legitimate grounds for processing the data. The right to be forgotten could also apply where the data involved were collected when the data subject was a child. So first, the data controller is going to have to assess whether the right applies. And then there are some grounds on which a request can be refused. For example, to protect freedom of expression, or where the data are required to deal with legal claims. As noted here in the last bullet on this slide, this might lead to some debates or questions as to how far data controllers are going to be able to refuse erasure on the basis that they may need to have the data in case of subsequent legal issues. So that's something to keep an eye on. In cases where no erasure is available, the data subject could instead seek to have the data restricted. That is only used for limited purposes and with restrictions on disclosure. Again, this illustrates how closely linked these rights really are. Where the right applies, the data must be removed, where the right does apply and the data has to be removed, and if the data controller has made the data public, the data controller has an obligation to tell others who have linked to or copied or replicated the data about their request. And you can imagine a number of practical scenarios where this might be difficult to pull off. Moving on to data transfer mechanisms. The next 3 slides are about cross-border data transfers, and I just want to pull out some headline points here for this discussion. The GDPR does not change anything with respect to the need to have a data transfer mechanism in place when transferring data outside the EU. The options generally remain the same, with the addition of a situation where the data importer certifies that they will comply with an approved code of practice. Binding corporate rules, which are known as BCRs, have become formally recognized under the GDPR, whereas before they were not specifically recognized under the directive. Model clauses, which are preordained contractual clauses between European exporters and, for example, American importers, and adequacy decisions of the European Commission, like the Privacy Shield framework that allows transfers from the EU to the US, will continue to apply. Of course, political forces are in play that could throw this into question, but for now, all of these data transfer mechanisms continue to apply. Note that in the GDPR, there's a new provision in Article 48 that makes clear that any judgment of a court or tribunal or any decision of an administrative authority of a country outside the EU, which requires a data controller or processor in the EU to transfer or disclose personal data, will only be recognized or enforceable under the GDPR if it's based on a mutual legal assistance treaty or the equivalent of an MLAT. Therefore, this is really important because this issue comes up all the time in U.S. litigation. An order of a foreign court or authority will not, on its own, be a ground to transfer data under the GDPR. Just a few highlights on these slides. As I mentioned, model contracts can still be used, and they do not require any approval by regulators. That's a bit of a change from existing law, where in some places there is a requirement for pre-approval by certain regulators. And the Commission may continue to make findings of adequacy for other countries. As you know, there's a dozen or so countries outside of Europe that have been deemed adequate by the European Commission, but they could continue to expand that list under the GDPR. In this slide, just know that there are some very, very limited derogations from the rules on or the restrictions on transferring personal data outside of Europe that include legitimate interests in limited circumstances, meaning you wouldn't have to have one of these mechanisms in place if you had legitimate interests, but be very careful about going too far with this sort of derogation. You also need to keep in mind that certain forms of technology that are very popular today, rely inherently on the movement of data around the globe in a 24/7 follow-the-sun model like cloud computing, and you're going to need to consider the transfer obligations when you're engaging with a cloud provider. Most cloud providers have thought about these issues deeply because obviously this is a significant aspect of what they do, but nonetheless, you'll have to think about this as the data controller. In terms of supervisory authorities and the quote-unquote one-stop shop concept, the GDPR also adds this one-stop shop element, which was originally conceived to alleviate the regulatory burden on companies that are forced to deal with multiple regulators across all 28 EU member states. Now, companies are able to select a main establishment, which for controllers means the place of central administration in the EU, or another establishment if that establishment makes relevant decisions regarding the data processing. This requirement also applies to processors where the main establishment is its place of central administration, or the establishment where the main processing activities take place. One really important point here, tags along to the Brexit discussion in Article 50 and the UK's triggering of Article 50. This requirement around main establishment requires the establishment to be in the Union. The UK will not be in the Union, and so you will not be able to rely, as many of our clients would like to do, on your UK office, which has traditionally been your main establishment in the EU. And so that's something that you're going to need to think about if that applies to you. If a company is able to avail itself of the main establishment provisions, which is not a requirement, but it's certainly an advantage, then it will have a lead supervisory authority that literally takes the lead in regulating that group company's cross-border data processing activities within the EU. I will say that during the legislative process, the one-stop shop concept was watered down a bit so that other member state supervisory authorities who are relevant to a particular matter may also get involved in the regulatory activities. This is what I've referred to above in the slides as a competent supervisory authority. When multiple supervisory authorities are involved, there's also a consistency mechanism in GDPR that allows the supervisory authorities to cooperate with one another. And sitting on top of this mechanism is the new European Data Protection Board, which is a board comprised of an individual from each supervisory authority who will resolve disputes between supervisory authorities over the application of the GDPR. So that's a nice concept. I mentioned sanctions in my introductory remarks. This is a headline for most companies when they're thinking about the GDPR. Supervisory authorities are allowed to issue warnings, reprimands, or mandatory orders, but there are two levels of fine that are just a massive, massive change over existing law. The lower level, which applies to certain issues like data security and breach notification, is a maximum of 10 million euros or 2% of the group's global turnover, whichever is higher. And the higher level of fines for other violations is 20 million euros or 4% of global turnover, whichever is higher. So as you can imagine, the potential for fines is astronomical under the GDPR. It remains to be seen how that will work. Obviously, there are different types of violations of the law, and you would imagine that this is not a situation where technical violations of the law are going to result in the book being thrown at you. But DPA supervisory authorities are newly empowered to issue massive fines, which has really never been true under existing law. Most GDPR breaches that attract fines are likely to qualify for the higher level fines because the smaller fines, which are not that small, are really limited to certain areas. So in terms of some highlights of what's happening in 2017, guidance from the national supervisory authorities, there is help available for businesses to prepare for the GDPR. There's various guides and leaflets which can be accessed, and regulators are working very hard to issue guidance. In my view, I find the UK's Information Commissioner's Office guidance on the GDPR to be particularly helpful. I think they really understand the issues, and they also take sort of a business view, so they understand the challenges that businesses face. And they've done so with respect to, so far, consent issues under the GDPR and privacy notices under the GDPR. And I would recommend that you visit the ICO's website at ico.org.uk and click on the Data Protection Reform link, where you'll find their guidance, and they'll continue to issue more guidance. The Article 29 Working Party, which is the group of data protection authorities at the EU level, published an action plan last year, and they've been working on guidance to the GDPR as well. They had a meeting in December, and they published guidelines together with FAQs on 3 key areas of the GDPR, including the right to data portability that I talked about, data protection officers, and the lead supervisory authority. They invited comments from various stakeholders before the end of January, this past January. They're also planning to issue guidelines on data protection impact assessments and certifications here in 2017. As this deadline approaches of May 25th next year, the EU regulatory community has been regularly reaching out to stakeholders, which in my view is a very positive sign. For example, there was a Fab Lab held in July of 2016, which was a workshop for regulators, industry, academics, and relevant associations to develop operational and practical issues under the GDPR. This was positive, and helped the working party come up with the guidance that they've issued. There's also going to be a May 2017 issue or workshop for non-EU regulators to have an opportunity to discuss their views on the GDPR and its implementation, which I also think is a very positive step. It's going to be really, really important to monitor these developments and to stay aware of the guidance being produced by regulators. Just keep in mind that this guidance is not a substitute for the very specific preparation that you're going to have to do and that each business is going to have to do internally to make sure that they're in a safe position vis-a-vis the GDPR. With that, I will turn it back over to Neil, and I thank you for your time.